Are cops allowed to legally surround your home with cameras and stalk you day and night for as long as they wish without a warrant? That is exactly what happened to an Illinois man by the name of Travis Tuggle. In this video, I'm going to explain if police surround your home with pole cameras and they begin to stalk you day and night and they don't have a warrant, is this legal? And what you can do to protect yourself so that you don't face the same situation and fate as Travis Tuggle. Back in 2014, police investigators, they suspected that Travis Tuggle might be involved in drug manufacturing. Instead of getting a warrant and showing up at his front door, investigators decided to go to Mr. Tuggle's home and install 3 cameras, and they mounted them on utility poles so that they could surround his property and monitor him. But detectives didn't stop there. They then used remote control technology to pan, zoom, and adjust to be able to get a 24/7 live feed of all the comings and goings inside the home of Travis Tuggle. In fact, they did this for over 18 months without a warrant. After 18 months of surveillance, the police were able to gather enough information to convince a judge that there was probable cause to execute a search warrant. After they executed this search warrant, they showed up and they actually found some drugs, which led to an arrest. After going to trial and facing a conviction, Mr. Tuggle chose to appeal his conviction on the grounds of a primary issue. The main issue in this case was police setting up mounted pole cameras surrounding his house, monitoring him 24/7 for over 18 months without a search warrant. Was this considered a search under the 4th Amendment of the United States Constitution? Look, the term search in everyday usage, when we use the term, means any purposeful investigation. We all search for our lost keys, or we search for information online. Anybody who applies the term search like we all use would believe what the police did here with Mr. Tuggle was in fact a search. However, what the law defines as a search is not always what we think of as a search. Tuggle appealed his conviction under the theory that what happened here was an actual search under the 4th Amendment. But unfortunately for him, the 7th Circuit Court of Appeals refused his argument, they denied his appeal, and the United States Supreme Court refused to consider it. Why? Let's unpack it. First, what is a pole camera? Pole cameras are high-powered cameras that include newer technology like night vision, thermal imagery, or artificial intelligence that help officers know where to turn and what to look for based upon AI algorithms. Now, when I say pole cameras are high-powered, many of them are so high-tech you can actually read lettering on the side of an aircraft from as far as 11 miles away, or you can read small serial numbers from as far as 100 feet away. Law enforcement admits that they are actively developing software that works with pole cameras that allows them to identify faces, allows them to read text and license plates, and be able to identify objects and filter through large amounts of information very quickly. If you think your local police department is not using pole cameras to spy on you, think again. It has been well documented that the FBI, the NSA, immigration enforcement, as well as all state and local police departments are actively using pole cameras to spy on people without a warrant. So in order to understand how police departments are actively using this technology without a warrant, we need to understand what the Supreme Court has defined a search to be under the 4th Amendment. Under current 4th Amendment search law, in order for your 4th Amendment rights to be violated, you must have a reasonable expectation of privacy in an area or object, and there must be an actual search of that area or object by law enforcement. But how do we know if we have a reasonable expectation of privacy? The Supreme Court actually gave us a 2-part test in the case of Katz versus the United States. Under this test, you have a reasonable expectation of privacy if number 1, and the court said this, that you have, quote, manifested a subjective expectation of privacy, end quote, and number 2, society has been willing to recognize your expectation of privacy as being reasonable. Now look, I know that sounds confusing. So in other words, in regular terms, what that means is you believed You had an expectation of privacy in whatever was being searched, and society has recognized that your belief in privacy was reasonable. For example, the court has found that putting up a fence around your backyard meets the test of having a reasonable expectation of privacy. You couple that with society has long recognized that if you put up a fence around your yard, there's an expectation that people are not going to be able to gain access into the yard, including public and police. In fact, courts have said that if it's actually the home that you live in, there is an even heightened scrutiny when it comes to privacy. But remember, even if there is a reasonable expectation of privacy, part 2 of the test requires there must have been an actual search. In order to know whether or not an actual search takes place, when police use poll cameras, they've broken it down into 2 primary categories. One is cops' visual surveillance of your home's curtilage. Now, your home's curtilage is the area that immediately surrounds your home, like your front porch, your side area, the immediate area in your backyard. That's number 1. Then number 2 is when police use video surveillance over a long period of time and they gather an enormous amount of footage and data. When we start to look at poll cameras and whether or not police using them for surveillance actually triggers a Fourth Amendment violation, we have to start with the reality that the Supreme Court has long held that visual surveillance, cops staking out your front yard or hanging out and just watching all night, that has not been seen as a search under the Fourth Amendment. However, the court has been much more picky about visual surveillance that exceeds, they use the word exceeds, the traditional sit and view with the human eye watching someone's home. This is when Fourth Amendment violations can sometimes kick in. For example, in Kylo versus United States, the United States Supreme Court ruled that when police officers use thermal imaging on someone's home, that is considered a search, and it became a Fourth Amendment violation in order for police to do this. Why? Because the Supreme Court said that this technology was not in, quote, in general public use. And they said it was also used to, quote, explore details of the home that would previously have been unknowable without physical intrusion. In other words, because the police were using non-public technology, not available to the public at the time, and that technology was used to see what was going on inside someone's home, that was a Fourth Amendment violation. But here's the problem. In customary style, the United States Supreme Court only applied this principle to that case in Kylo with thermal imaging. They did not provide us any specific guidance on how to apply Fourth Amendment violations to new technology. In fact, it seemed like they gave the police even more latitude here because they went back and said that they reaffirmed their original holding in Dow Chemical versus United States, where they held there that, quote, the mere fact that human vision is enhanced does not necessarily give rise to constitutional problems. In the Kylo case, the main thing that the Supreme Court seemed to have a problem with is that this technology was being used to search the inside and the curtilage of someone's home. And that's the primary reason they gave this heightened scrutiny and found it to be illegal. We have been covering how cops can set up poll cameras to spy on your home. But did you know that hackers and con artists are also trying to snoop on you? I was hacked, and I know how this feels firsthand. Hackers are sending sophisticated scams into your email inbox, and they are making personal calls to you, trying to bait you into a phishing scam so that they can get access to your personal and financial information. I learned firsthand that marketers and hackers are tricky because they find ways to buy your data from companies that you signed up for campaigns in the past. Here's the reality. It's impossible to live in the digital age that we're in today without sharing some of your personal information with other people. Whether it's signing up on websites or making trusted purchases online, you never really know for sure if your data is protected. Why? Because we see companies sending out notices all the time, apologizing that they had been hacked and now your personal information has been compromised. To make sure you are not victimized, this is where Incogni steps in. They are the best in the business at doing one thing. That is targeting your information and removing it from these people's lists so that you cannot be victimized. In fact, if the company refuses to remove your information from online, they will fight tirelessly to make sure you get over the finish line. When I got hacked, I learned the hard way that my information was out there and I was vulnerable. I wish I had known and trusted Incogni before I got hacked so that I could have had the assurance to know that my personal information was not at risk. I learned my lesson the hard way, and I will not repeat that mistake again, which is why Incogni has a very special offer for all of us. The special link attached here and in the description of this video provides a huge discount of 60%. I can personally attest, this is worth looking into and investing in. I very much appreciate Incogni sponsoring this channel and even more so protecting us from the predators that are online. I encourage you to check out the link below and take advantage of this great offer. Back to how cops can set up cameras to spy on your home and what you can do to protect yourself. Finally, the other exception when visual surveillance by the police can constitute a search and violate your rights is under a theory known as the mosaic theory. Under this theory, courts have said that if the police use new technology and they just gather large sums of information from lots of people and they bring it all in at one time, that volume of information may be so much that it now becomes a search. Now look, I don't want this to be confusing, but here's what it comes down to. Now we have federal circuit courts of appeals that are split on this issue. Is a poll camera, the use of a poll camera by the police, an actual search? It depends on what circuit court you're looking at. Let's start with the Fifth Circuit. In 1987, the Fifth Circuit ruled in the case of United States versus Cuevas Sanchez that continuous 2-month-long use by law enforcement of poll cameras to examine someone's backyard area, that was considered an illegal search by the Fifth Circuit. But the Sixth Circuit in United States versus Houston ruled exactly the opposite. In that case, the court held that a 10-week-long poll camera surveillance of someone's home was not a search and was not illegal, no matter how long the police chose to do it. In U.S. versus Jackson, the 10th Circuit Court of Appeals ruled that warrantless poll camera surveillance of someone's home was not illegal and it was not a search or a violation of the Fourth Amendment. Why? Because it was primarily observing the outside of someone's home. In fact, they said specifically, if the cameras are set up and whatever the camera sees is the same thing that someone walking down the street could see, then it's not a search and the police can do it as long as they want to. Finally, to make things even more complicated, the Fourth Circuit Court of Appeals applied the mosaic theory we talked about earlier in the case of Leaders of a Beautiful Struggle versus the Baltimore Police Department. In that case, the Fourth Circuit Court of Appeals ruled that a surveillance program that allowed them from a blimp to be able to see everything that was going on throughout the city of Baltimore was a violation of the Fourth Amendment. Why? Because it was capturing data and information from everyone and everywhere all over the city. And because of that volume of information, under the mosaic theory, that was illegal. So what does this all add up to? It adds up to the final Seventh Circuit. We're going to talk about the Seventh Circuit. They ruled against Tuggle because in that situation, they applied Katz's two-part test and found that Tuggle failed them both. How? Well, part one, they said that Tuggle did not have a real expectation that his yard was private. Why? Because he didn't take any specific measures to keep it out of the view of the general public. And if the general public can walk around and see your front yard, then you should expect that the police can hang out for 18 months and watch your front yard too. And then part two of that test, the court said that Tuggle had no reasonable expectation of privacy because all of society would not expect that anybody who can see anything from the road to your front door, no one should expect any of that to be private. So as a result of that, the court held that he failed both of those tests. But doesn't this kind of bring up some problems? Because remember what we talked about earlier, that these poll cameras have some advanced technologies and they can see a lot more than what the naked eye might can see? The court said, and they recognized, that it could be a problem, but it's not a big enough problem to create a Fourth Amendment violation. In fact, the court just assumed that these poll cameras were primarily only being focused on seeing who was coming to the front door and who was leaving, and the comings and going of what's going on the outside of the home. And as a result of that, they believed that any officer who may want to do a stakeout could have seen the exact same thing as the poll camera. Finally, what about that mosaic theory we talked about earlier? Remember, it says if you gather a lot of information over a period of time, it could be a Fourth Amendment violation. Wasn't 18 months a long enough time to be considered a violation under the Fourth Amendment? Crazy enough, the Seventh Circuit absolutely rejected the mosaic theory. In fact, they said there's no binding precedent or authority that requires us to even recognize this particular theory. Now, here's what drives me crazy about these appellate courts. After ruling for the government and saying there is no Fourth Amendment violation, they then go on to say, hey, look, this might be legal, but the fact that the police are using these poll cameras all the time and surrounding people's homes with them, it might be legal, but that's really disturbing. I really wish they wouldn't do that. In fact, the Seventh Circuit went so far as to say that using these cameras for 18 months seemed to be too long. But they didn't feel very comfortable on where exactly to draw the line to call it a Fourth Amendment violation. The Supreme Court refused to consider Tuggle's case, so now we're left with split decisions amongst appellate courts, which means the police are likely to continue to use this technology for as long as they can until the Supreme Court gives us some clarity on where the Fourth Amendment violations will actually kick in. So here's the real question. What can you do to avoid being surveilled by the police with poll cameras in front of your house for 18 months without a warrant? First, it will come down to where you live and which Circuit Court of Appeals will apply the law in your area. As we said earlier, some courts, like the Fifth Circuit, have ruled that police must have a search warrant if they're going to use a poll camera to surveil your home. But then others, like the Seventh Circuit and the Tuggle case, they have ruled that the use of poll cameras for almost an indefinite period of time is still not considered a search, so cops can legally do it. So here's what's key. If you live in an area like the Seventh Circuit, then it's important that you can pass the CAT's two-part test to establish an expectation of privacy. And remember what we learned. The only way to do that would be maybe to put up a fence, create an area that shields your yard, whether it's your front yard or your backyard, from public view. And under that example, now you can establish both a subjective expectation of privacy, in other words, you expect it to remain private, and society would recognize that expectation of privacy because fences have been recognized for people to stay out. So for me, what I would do is put up a fence, guard that area so that the public cannot see it, put up a no trespassing sign. You're able to establish an expectation of privacy from the police. The problem? Some local municipalities try to put limitations on the use of privacy fences or how high you can make your fence. This is precisely why the United States Supreme Court needs to tackle this issue and stop law enforcement from using poll cameras for years on end without any checks and balances to invade your privacy. Now, are police allowed to use technology that simulates a cell tower in order to trick your phone to turn over your personal information without a warrant? Check out this next video where I break down how police are using cell site simulators to trick your phone into giving up its data and what you can do to protect your privacy. See you over there.